I'd like maybe to ask you both to drill down a little bit into the substantive issues that you've alluded to a little bit obliquely. One of the mistakes I think that I've heard discussed quite a bit that Robert Bork may have made is that he said what he believed and laid out there what his views were and encountered the problem of those views not being in touch with a large chunk of America. Can you talk a little bit about how that experience has changed the nominations process and maybe how that's affecting the way these nominations are playing out today?
Well, certainly the one big lesson from the Bork experience, as Pam alluded to, for any nominee is I'm not going to say anything I don't have to get confirmed. Less is more. If I were advising Sam Alito or John Roberts, I would have counseled them to say as little as they did, maybe even less still. There's no upside to being honest and forthcoming if you've already got the votes in the Senate. I think one problem is, and maybe this is part of the problem with the media, part of the problem with the legal establishment, there hasn't been a good enough job done in exploding the fiction that it is somehow problematic to ask about substantive views, that somehow prejudges cases, that somehow commits a jurist to voting a certain way once they take the job. I mean, if the idea that you tell what your tentative views on a subject are somehow disqualifies you from then ruling on that subject down the road, then no sitting justice could ever rule on a case in which he'd already written a concurrence or a dissent or a majority opinion. I mean, Anthony Scalia could never hear an Establishment Clause case because he'd already laid out his view of the Establishment Clause in prior cases. But you'd be surprised at how many intelligent people and even intelligent lawyers still kind of buy into this idea that, pointed questions about specific views in specific cases is somehow off limits. So because, it's not clear that that's a fair question to ask, and because, nominees aren't going to offer any more than they have to, you're not going to get a lot of information. You're not going to. I mean, Pam said earlier, the American public probably doesn't agree with much of what Sam Alito believes as a matter of law. And yet, unless we can kind of force nominees to share that, there's never going to be the political check that Senate confirmation was designed to provide in reality.
I just want to pick up on that point. Is the fact that the American public doesn't agree with him a legitimate basis for rejecting a nominee?
Sure. I mean, I go back to the point. I think there are a lot of senators who don't feel enough pressure from swing voters in their states to really care. I mean, there are very few senators who feel like their ability to be reelected really turns on what they do in confirmation. But I do think that the Senate confirmation was intended to allow the American people through their elected representatives to have some input into the president's choice. And certainly if the American public doesn't think somebody is the right guy to be or the right woman to be on the court for the next 40 years, that's got to count. In the same way that it should have counted that the American public was not in favor of removing Bill Clinton from office. I mean, the impeachment shouldn't have gone forward because of that public sentiment.
Yeah, I mean, two things. One is, the president ran on, in part, the platform. He would name more judges like Justice Scalia and Justice Thomas. So presumably the people who voted for him because they wanted him to do that, and that's what he should try to do. Senators who run on, I am a Democrat and I believe in this view of the law, or even I am a Republican and I believe in a sort of moderate view of the law, they have the same entitlement to vote against somebody because they think that's what the judge is going to be. And two quotations I want to kind of point out to you, both of them from Justice Roberts. One of them from the original Justice Roberts, one of them from the current Chief Justice. The original Justice Roberts, you may remember this from first-year common law. There's a really boring spending clause case called United States against Butler, and there's a concurrence there by Justice Roberts, and first Justice Roberts says there, here's what we do when we do constitutional interpretation. We take the statute that's being challenged, and we lay on top of it the constitutional provision that's being invoked, and we ask, does it fit? In other words, it's sort of like, putting on clothes. You go in and you try on the clothes. If things are hanging out the sides, the muffin problem, you all know what that means, right? Then that's not the right size for you. If it's so baggy it won't stay up, that's not the right size for you. It's mechanical, right? I mean, fit is not really about, can I stand like this? And if I stand like this the whole time, it actually will fit me. No, I mean fit is a kind of objective idea. And then the second Justice Roberts, and that Chief Justice, said at his confirmation hearings that he really views the job of a judge as being like an umpire. You're not playing the game; you're just calling the balls and strikes. No one seriously believes either of those statements. That is, you don't figure out whether something's constitutional or not by taking the law that's being challenged and popping it on top of the constitutional provision and seeing if little bits of it are hanging over the side like a hamburger knuckle properly on a bun. It involves interpretation. If anybody knows anything about baseball, knows that different umpires have remarkably different strike zones, and that the strike zone, even leaving aside what the rule is, the strike zone has shifted dramatically over time. So it matters who's calling the balls and strikes. It's not mechanical. This is not like, asking somebody to figure out whether the pages of the laws are consecutively numbered. And so I think it's perfectly appropriate for people to say, this person's really smart. John Roberts is a very smart man. He's very talented. He writes beautifully. He's very well educated. People who know him say he's good to his children. He's nice to his community. He's, the one case I litigated in which he was involved, he was very courteous. That doesn't mean he should be on the Supreme Court. The Supreme Court's not a reward for being a good boy. Right? And I think part of what we have to get away from is the idea that if someone is smart enough and personally honest enough so as not to be disqualified from being on the Supreme Court, then he or she deserves the job. But this is not like grading onto law review. You got the grades, you get on. And I think that's something that people have been really resistant to. And the result of this is you're constantly looking for personal reasons to keep people off the Supreme Court. The problem with Justice Alito was not he ruled on some case where he owns some shares of a mutual fund. That's not why you should oppose him or support him.
Or what alumni group at Princeton he belonged to. It should be what his views are. And to build on what Pam just said, part of this myth that all we should look at is whether someone is smart enough and experienced enough and has the right temperament and a collegial attitude. A related myth is that somehow the president's presumptive pick is entitled to go through unless there's a big flaw, that the presumption should be in favor. There's no other constitutional process that I'm aware of where the actor who goes second is entitled to consider anything less than the actor who went first. When the Senate considers legislation, it can consider exactly the same policy reasons or not that the House did in rejecting it. The President can veto a piece of legislation and revisit the same policy rationales that convince both the House and the Senate. In the treaty-making process, the Senate isn't bound by the President's sense that this is a wise treaty to have. Just because you go second doesn't mean that you can take into account any less than what the first one did. Now, maybe as a practical matter, once the president puts forward in front of the American people kind of an attractive, compelling life story, and it's a little harder politically. But analytically, they're partners in this. And everyone knows and concedes that the president is taking into account Roberts' views when he picked him. He's not just looking to see where Roberts went to law school. I mean, there are liberal versions of Roberts who are every bit as smart and every bit as pedigreed, and Bush wasn't looking at any of them. So if the president can consider ideology as a paramount factor, there's absolutely no reason why the Senate can't or shouldn't.
So, to finish this one point before we move on to looking forward, what are the things that in the president's mind, or the minds of the actors on the far right who are